I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're with my time, you're delirious. Mysterious
response to the state's motion in limine, and I think the issue right now is what do we do about each specific 8033 statement or testimony, whatever that is. And the thing to do, Mr. Goodman, in my view, is the state should not refer to any of those statements until the court has an opportunity to have a jury out hearing. It may not be, if there's an objection, we'll have a jury out hearing on anything of that nature. It's that simple.
Judge, but I was doing it based on your order. Your Honor said that 2 or 3 things can possibly be admitted.
Right.
My motion, just out of abundance of caution,
Right.
is don't bring any of these things up until we do have a jury.
Right.
I'm letting the court know that in my motion and the statement, and I'm asking that they not be mentioned as a particular objection, so I'm letting you know. I'm asking the court against. Thank you, sir. Well, yeah.
Now you're on, I can see the green light.
It's probably better off. I'm just asking that there not be mentioned until we have a jury out hearing.
I think that's the way to deal with it. We'll, you know, if it comes up, there won't be any mention of any 8033 statements until they've been admitted by the court, and nothing's been admitted at this point.
Just let me make sure I understand, because you originally said there would be a jury out hearing if there is an objection.
Right.
So in other words, I have to ask the question.
Absolutely, you do.
Well, okay, so it's not going to be a situation where I say, okay, Judge, I'm getting ready to ask these questions. Let's do a jury out hearing.
I'm good with it that way too. If you say I'm getting ready to get into this particular kind of testimony, then I'll send a jury out. We'll get them all out there right now. You can put your stuff on. We'll deal with it.
I'm saying the prosecutor needs to stop and then ask their approach, and then we'll have the jury out hearing before it's even mentioned.
Is that a problem?
It shouldn't be argued in opening either until none of these things
Judge, I don't want to be held to that if I ask something that I don't think is actually this order pertains to, and there's an objection.
I understand.
If I know that it's something that you've already addressed, then yes, I will. But I mean, there could be other questions that may be the same situation.
I understand. I'm not trying to tie your hands, but if you know that it's a statement that I've already said,
right,
I've got to determine whether it's unfair, whether the timing and the context are right for admissibility under the exception, then I need a chance to deal with that without the jury.
Yes, sir.
Otherwise, I understand. And if there's an objection, then I'll deal with the objection.
Yes, all right.
Okay. I think we're on the same page.
Okay. That's why I filed the motion, just out of abundance of caution, and then I received Your Honor's ruling.
Yeah.
And then Your Honor, in essence, stated we have to have a jury out. And I will object, but the things that you excluded, I'm asking for a jury out hearing before it's mentioned. All right.
What was the other?
And that means opening too. The next thing, Your Honor, is I did ask for the rule of sequestration after jury selection. And I do ask that my expert, Mr. Williams, and my investigator be excluded from that. Now, he's not here. So they have an expert about these digital and things, and we gave notice about ours too. And so generally it's allowed that experts can listen to the other expert testify because it may affect their testimony. And that's why I'm asking for it. Now, my investigator, she's helping us control witnesses and things of that nature. And I don't anticipate her being a witness, but I do ask for her to be excluded from that rule.
Okay, well, let's take one thing up at a time. One is you want witnesses to be excluded from the courtroom. When do you want that in effect? Before opening statements?
Yes, sir.
Okay, but and that's when I generally will ask if anybody calls for the rule. Is that point? I anticipate we get the jury in, get everybody sworn the way they need to be, and then I'll do preliminary instructions, and then you're going to read the indictment, and then before opening statements, I will call for the rule.
Yes, sir.
Okay?
I do ask for those two exclusions.
Well, I mean, I'd like to see some law on it. He says this is the custom. I haven't received any notice of this, and it's not been the custom anywhere where I've practiced. I'm sure I don't have Mr. Taylor's experience.
I'm talking about experts.
Right.
And I'm talking about one expert. They have an expert, we have an expert on the same subject. The rules allow for an exception to the rule of sequestration for the other side to hear. That cuts both ways. And so that means theirs and mine. And so under our rules, there's experts can be allowed to hear the testimony of the like witness. Now the others, and they're an exception under the rules of sequestration for experts.
Yeah, I just want, what's the state's position?
Well, we got the same book. I'm waiting for him to say which rule.
Under expert testimony,
traditionally, opposing experts have the opportunity to hear facts and expert opinions of the other side in order to be able to respond to opinions that are rendered. And as Mr. Taylor points out, the rule does cut both ways. Your experts are certainly permitted to remain in the courtroom during any defense expert testimony for rebuttal purposes if you choose to do that. So what I'm thinking, Mr. Box, unless you can find something that tells me otherwise, that is the traditional way. And it's not, I don't think it's a part of the rule of sequestration, but I think case law under the rule is pretty clear about it.
Okay.
so I've asked for those exceptions.
So right now, that's the way. If you may find something tonight,
I still don't see reference to the rules of evidence, John. That's why I'm asking.
okay.
It is an exception. It's black letter law, case law. I mean, you get to listen to our experts.
I get that.
We're not required to follow notice.
Yeah. Everybody got their audio, visual they need. We got everything. What do we need to do with the televisions right now?
And also, one other thing, the tire experts, he's also another exception. Both sides have somebody that may testify about the tires.
Right.
So that would be another exception.
I thought that was included in what you were asking for the time.
You got cell phone, we've got records, Mr. Williams, and they've got people from the TBI. And then there's the issue of the tire. They have somebody that's going to testify about the tire examination. And then we've given notice that we have and given a report that we're going to have somebody. So there are exceptions to the rule of sequestration for those
Okay.
witnesses. And then our investigator.
And that's fine. Cell phone expert wants to sit in here, but we'll let the court know now, we will be objecting to that expert.
I'll have to cross that bridge when we get to it.
Yes, sir, just going to put you on
Okay.
notice that that's going to be coming.
I understand.
Which one?
I understand. We,
We did give notice.
let's deal with it when it becomes an issue. I can't anticipate and deal with everything, until it's actually, you may or may not call somebody. It just depends.
Yes,
And we'll deal with it then. Is there anything else we need to take up then before we?
That's all I can think of.
Beg pardon?
That's all I can think of.
Okay. All right, good deal. Let's get our officers together, as many as we can, there. Anybody that's going to be working with the jury at any point? Mr. Jones is going to administer the oath. You ready to go? All right.
Yes.
We've got them. All right. Any of the officers going to be working with the jury, if you'll come up and raise your right hand for me. All right, Mr. Jones.
You as officer designated to serve with the trial jury solemnly swear you will faithfully discharge such duties that you will render any and all assistance to the trial jury while in performance of their duties, otherwise discharge your duties as sworn officers, so help you God.
All right. Thank you all very much. Hey, Gavin, you'll let me know how many jurors you got? 7. 7. Okay. So we're going to be in recess till we get all the jurors in. Okay. All right.
All right.
I don't know where I'm going. I can't go back there. Huh? Just tell me everybody sit down. Two right there, and then a nice blue chair for somebody. It's good. Let me more in this case. Anybody had a problem there? You're obligated to report to me any efforts to do that, if you'll do that. If you will be sure and do that. Mr. Tom Jones, who's the circuit clerk in Dyer County, is now going to administer the juror oath to you. So, come on up, Mr. Jones.
Zero, raise your right hand. Do you solemnly swear you will well and truly try the issues in order the case the state shall receive or submit with true verdict render and render any and all deliverance made according to the law that is in the case. So there you go.
Is anybody who did not accept the oath of the juror? I'm hearing some back feed. Yeah. Ladies and gentlemen, before we begin the trial, I want to tell you a little bit about what will happen during the course of the proceedings and describe how the trial will be conducted. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision, but for now I want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charge is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged with first-degree premeditated murder. The essential elements of the offense are listed below. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. The defendant has pled not guilty to the charge. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the jurors in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, the attorney for the defendant may make an opening statement if he should choose. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After you have heard all of the evidence, the state and defense may present final arguments. Final arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After hearing my instructions, the jury will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. I will decide which rules of law to apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raise during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. A defendant is not required to prove his innocence or have his attorney make any statements or arguments or to produce any evidence. You must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as being honest? Did the witness have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events about which he or she testified? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decision on the fact that there were more witnesses on one side than the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. You have probably heard the terms circumstantial evidence and direct evidence. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. You may consider both kinds of evidence, which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you are allowed to take notes during the trial for your own use during your deliberations, but you're not required to take notes. Independent memory can be as accurate as written notes. You'll be provided and have been provided with pen and paper if you decide to take notes. During the course of the trial, you should not talk with any witness, the defendant, or any attorney involved in this case. Please do not talk with them about any subject whatsoever. You also should not discuss the case among yourselves until I instruct you on the law and you begin deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all of the evidence you may properly consider to decide the case. Because of this, you may not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not engage in any outside reading, visit any places mentioned in the case, or try to learn about the case outside of this courtroom in any other manner. There are numerous media reports in the newspapers, on television, or on the radio about this particular case. Additionally, there may be broadcasts or streaming of the trial. You are not permitted to read, watch, or listen to those reports or discuss the content of the trial with anyone, including your closest friends and family members. As jurors, you must base your decisions solely on the evidence that you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask or submit questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence that is presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have a conference here at the bench in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I'll try to avoid as many of these interruptions as possible, but I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. If, after your deliberations, you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. This completes my opening statements to you. We'll now proceed with the reading of the indictment. General Goodman.
Indictment. In the Circuit Court of Dyer County, Tennessee. State of Tennessee versus David Swift. Indictment for first-degree premeditated murder. The date is August 8th, 2022. Indictment number 22 CR 186. The grand jurors of Dyer County, Tennessee, duly impaneled and sworn upon their oath, present that David Swift, on or about October 30th, 2011, in Dyer County, Tennessee, and before the finding of this indictment, unlawfully and knowingly, with premeditation and intent, did kill Karen Swift in violation of Tennessee Code annotated 39-13-202 and against the peace and dignity of the state of Tennessee. This indictment is signed by me, Danny Goodman, Jr., District Attorney General, 29th Judicial District, and also a true bill by the grand jury foreman, Walt Bradshaw.
Ladies and gentlemen, the defendant pleads not guilty to each charge embraced in the indictment. The rule of sequestration has been called for in this case. Any person that's going to be testifying in this case will need to wait outside.
State would like to announce that we have Chief Investigator Terry McBride as our party in interest.
Thank you. All right, we're ready to proceed with opening statements. Ladies and gentlemen, as I told you a few moments ago, opening statements are an opportunity for the lawyers to give you a preview of what they expect their evidence to show. Opening statements are not evidence. The state goes first, then followed by the defendant if he chooses to do so. General?
Good afternoon, ladies and gentlemen. First of all, I want to thank you for your time and attention to this matter. It's a very important issue, and we need you to pay close attention, and we appreciate the fact that you're here and willing to do that. Unlike cases that you see on TV, shows like CSI or Law and Order, this is not one of the cases where you're going to see positive DNA results. You are not going to see fingerprint analysis. You're not going to see ballistic testing. There are not going to be any of those things in this case. We will, however, give you several pieces of a puzzle. And when we get through giving you all of those, we think that we're going to have a complete picture, and you're going to see that complete picture of exactly what happened to Karen Swift. Once you put all those pieces together, we're going to ask you to find David Swift guilty of first-degree premeditated murder. I want to start by giving you some background. David and Karen Swift were initially married in September of 1989. They had two children, two sons, Preston and Dustin. In 1996, Mr. David Swift had a 3-year affair. And out of that affair, a child was born. Ms. Swift found out about the affair about the time that the child was born, and she filed for divorce. The divorce was granted on January 18th of 2000, and after being divorced for several months, Mr. David Swift and Karen Swift decided that they wanted to try to give things another chance. So the two of them were remarried, and they were remarried in that same year that they divorced, and they were remarried in September of 2000. After being remarried, 2 more children were born. They had 2 daughters, Ashley and Keely. After being married several years that second time, Miss Karen Swift had an affair. And she had an affair with a gentleman in Arkansas. And upon discovering that, Mr. Swift decided that they needed to move. And that's your first indication, and you're going to find out throughout the trial, that Mr. David Swift wanted to control every aspect of Karen Swift's life. Once he found out about that affair, he abruptly made the decision to move his family from Arkansas to Dyersburg, Tennessee. And that's regardless of the fact that his job was actually in Arkansas. But he moved his family to Dyersburg, Tennessee. And they moved so quickly that Miss Swift never actually got a chance to look over the house very well, see what the house looked like much. And they left so fast that they left their oldest child, Preston, in Arkansas to finish school. After being in Dyersburg for some time, Karen Swift began to make friends. This is something that the defendant did not like. He wanted to keep his thumb on her at all times. You're going to hear that many of the friends throughout this trial are going to testify, and they're going to tell you that Karen Swift was very unhappy in her marriage, and she wanted a divorce from the defendant for a long period of time. Miss Swift started to hang out with some friends. She had a neighbor who lived across the street. Her name was Jenny Guerin, and you're going to hear from her. And she also met a person who became a very good friend to her, and this was through a dance school. This person has a dance academy where they teach children to dance and do performances and competitions and those kind of things. Her name's Kathy Bona, and you're going to hear Kathy Bona and Bill Bona's name a lot throughout this trial. Karen spent a lot of time at their house. She spent time at Jenny Guerin's house. She spent a lot of time at Kathy and Bill Bona's house. You're going to hear testimony that the defendant did not like that at all. And the minute Miss Swift would leave the house, he would start calling, he would start texting, and it was constant. It was every few minutes he would call and text. And then it got to the point that wasn't good enough anymore. So then he started having stalking behavior. And he was seen just popping up at all times where Miss Swift was. He had to keep his thumb on her and know exactly what she was doing. You're going to hear from Janie Helm. Janie Helm is a neighbor to Kathy and Bill Bona, or she was at the time of this incident. She's going to testify, and she's going to tell you that she came outside one day and she was startled by the defendant who was in her yard. And he told her, "Shh, be quiet. I'm trying to listen and look through your fence and see what's going on next door." So he was trying to spy on Karen. He was trying to listen in through the fence. And Ms. Helm told him, "You can't do that. You need to leave my yard and don't you come back." You're going to hear from numerous friends. They're going to tell you about times that the defendant was stalking Karen, about the fact that he was not welcome to be at their homes. You're also going to hear that David and Karen Swift were having severe financial problems during the year of 2011. But regardless of the fact that they were having all these financial issues, Mr. Swift still did not want Karen to work. If she went to work, she may meet someone. She may meet a friend. He may fear that she was going to meet another man. But he wanted her at home and not working. Because of that, I told you earlier that Miss Swift wanted a divorce for a long period of time. The problem with that was that she didn't have the money to file for divorce. Mr. Swift controlled all the money. He controlled the finances. She didn't have any money, and she couldn't file for divorce. Despite the fact that the defendant did not want her to work, she started trying to do some things on her own. She started doing some landscaping work, and she even started to clean houses some. And she did that in an attempt to try to make money in order to get that divorce. In October of 2011, you're going to hear that Bill and Kathy Bona loaned Ms. Swift $2,000 to file for that divorce. In addition to that, they also loaned her a cell phone. And this cell phone was called a Voyager. That was the name of the phone. And you're going to hear about this Voyager cell phone throughout the trial. They loaned her this second phone because she needed a phone that she could talk to her attorney without the defendant being able to monitor her calls, monitor her texts, and know exactly what she was talking to her attorney about. So she was using this second phone for that purpose. You're going to hear from Jason Creasy. Ms. Swift hired Mr. Creasy to represent her in the divorce, and she actually filed that divorce in October, and but she was afraid to be around when Mr. Swift was served that divorce. So Kathy and Bill Bona had already reserved a room. They were going on a vacation for fall break. The children were out of school for fall break, and they had rented 2 condos. Well, one of the couples decided not to go, so they just had an extra condo that was already paid for. So they told Ms. Swift, said, hey, why don't you just get the girls and come down with us? And that way, while he's being served from the divorce, you won't be at home. You won't be around. So that's exactly what she did. The thing was, she didn't tell the defendant that that's what her plan was. So she took the children, and she left to go to Orange Beach. She did leave a note for the defendant. She left him a note and said, I've filed for divorce. I've taken the children with me. I'm not going to tell you where we are because I don't want you to come find us. And I'll let you talk to the girls as soon as we get there. We'll call you, and I'll let the girls talk to you. But you got to promise me you won't ask where they are because I don't want you to come down and find me. She also told him that to keep him from being embarrassed and being served at work or being served by a police officer somewhere when he was out, that he could go to her attorney's office and he would just serve him and give him the paperwork. And she did that to try to to benefit him, just to make it easier so that he didn't get served at work with divorce paperwork. Mr. Swift did do that. He went, and on October 10th, 2011, he accepted service of the divorce at Jason Creasy's office. Some of you had talked about the fact that you had been divorced or been through one. One of the things about a divorce is once you are served, you have 30 days to file an answer to that divorce. If you don't do that, there are some consequences, and you'll hear about what those might be later on. Even though the defendant had 30 days to file to file an answer to the divorce, he never did. He didn't file that answer because Karen Swift was killed before that 30-day period ever arrived. You're going to hear proof also that those divorce papers that he was handed and was served with were found in his trunk under a spare tire. And that doesn't sound like a person who intends to give that paperwork to an attorney and file an answer. The state submits that the defendant started planning the murder of Karen Swift several days before her before her death, and shortly after receiving the paperwork for the divorce. You're going to hear that the defendant had a knee injury earlier in the year, and he did. He had a legitimate injury that happened around April of 2011. But he had surgery for that. He went through rehab, and his knee had gotten stronger. And it was healed to a certain degree, and you're going to hear about that injury as well. But what you're also going to hear is that his knee was strong enough to lift and move hay bales the day before she was murdered. What you're also going to hear is the next day, after lifting those hay bales, and Miss Swift was missing, that he was on crutches all of a sudden. He's going to tell you that he had injured his knee at work on October 25th, just a few days before her disappearance and murder. This was Mr. Swift's first attempt to plan and to attempt to cover up the murder that he was planning. You're going to hear from witnesses that are going to tell you that the defendant's knee appeared to be fine the day before Karen's murder, but on the day that she was murdered, he was using crutches. Witnesses are also going to tell you about numerous lies the defendant told after Karen was thought to be a missing person. Because what you're going to find out from the proof is that Ms. Swift went missing on October 30th, but her body was not found for 40 days. So during this period of time, the defendant started to demean Ms. Swift. Now, typically, if your wife was missing and you still loved that person and you didn't want a divorce, you would think that you would be talking about how much you missed her and how much you loved her and what a good person she was. But the proof's going to show that Mr. Swift did the opposite of that. Anyone that he could talk to and talk about what a bad person she was and to demean her character, he did that. He tried to portray her as this wild party girl who was just seeing multiple men everywhere. Now, on October 29th, 2011, that's the day before Karen Swift was missing and murdered, Karen planned to attend a Halloween party. The Farms in Dyersburg is a country club, and a bunch of people had gotten together and they were hosting this party, and it was going to be a costume party. And there were lots of people in Dyersburg and Dyer County that were going to attend this costume party. Well, Karen decided she wanted to go to that party, so she did go. She went along with Kathy and Bill Bona. Now, the defendant was still trying to prevent a divorce on that date. And he actually asked Ms. Swift if she would not go to the party, but instead go to dinner with him. And let's talk about things and let's see if we can work things out. She refused to do that. And she basically said, look, David, it's over. You need to accept it. It's over. I'm not going to dinner with you. I'm going to this party. You're going to hear from Janie Helm, once again, the same person who he was in her yard looking through a fence. You're going to hear that night that the defendant showed up at the Dyersburg Mall. And she was there working in a store that her sister owned and was helping her sister. She's going to tell you that the defendant came in and talked to her and that he told her that night that he did ask Karen to go out with him to dinner. And he told her that she refused to go. And Ms. Helm is going to testify that the defendant appeared to be furious. And he was really, really angry that he had been shunned by Ms. Swift. And that she would choose a party over him. Now, their daughter, Ashley, who was the older daughter, she was spending the night with a friend that night. And the younger daughter, Keely, was staying at home with Mr. Swift. You're going to hear from witnesses that while at the party, Karen did not dance with anyone other than just the friends that she had in her group. I'm sure all of you have seen a group of people dancing where it's men and women and everyone in a circle or in a group dancing. That's the only kind of dancing she did that night. She didn't dance with any other men. She didn't dance alone with anyone, only with the groups. You're also going to hear that while she was at that party, she never got in an argument with anyone, that it was a good, calm night, nothing was going on, and she stayed with her friends throughout the night. They all pretty much just stayed together, sat at the same table, just enjoyed being with one another. They left the party, and when I say they, I mean Karen Swift, Kathy, and Bill Bona. They left the party a little after midnight. They decided that they would go by McDonald's in Dyersburg and get some French fries. And they were going to go back to the house, and Miss Swift's plan was that she was going to spend the night with the Bonas that night and just sleep on the couch. They got home from McDonald's. They sat in the house in the living room for a little while. They were eating their fries. They were just talking about the night, talking about things that had happened. And Miss Karen Swift received a phone call from Ashley. And that's the oldest daughter. And if you'll remember, she was spending the night with a friend. This was a little after 1 a.m., and Ashley told Miss Karen Swift that she wasn't feeling well. There had been some issues with the other girls there, and she wanted to come home. And you're going to hear a lot of proof about what a great mother Karen Swift was. So she immediately dropped everything she was doing, changed her plans, and went to pick up her daughter to bring her home. While she was doing that, the defendant, Ms. Karen Swift called the defendant. And she told him, said, hey, Ashley's not feeling well. I'm on my way to pick her up, and we're going to be on the way home as soon as we do that. Mr. Swift told Karen Swift that Keeley, the youngest child, was in bed with him, and you'll find out that they slept in separate beds. Mr. Swift slept upstairs, and Miss Swift slept downstairs. And that's something that had gone on for a good while. So the defendant told Miss Karen Swift, Keeley's with me, she's in bed upstairs, and what I need you to do is to use the side door to the garage. So he told her specifically which door he wanted her to come in. This was a little bit unusual that he would ask her to come in that side door, because he always kept the garage door open. So that was strange, and that's a part of the planning. It's a part of the premeditation. It's part of what Mr. Swift was planning to do later that night. Now, in 2011, you need to remember back, this was 13 years ago. Technology was not as good 13 years ago as it is today. Now, we did have cell phones, and I know all of us remember when we didn't have cell phones, but we did. But the service was not quite as good in some areas. And Mr. and Ms. Swift lived in a rural area, so the service was not quite as good out there. But Mr. Swift was required to be on call with his job. So his job furnished him a network extender. And what a network extender would do is it will boost your signal. And it's kind of like now where you go home and you hook to Wi-Fi. As soon as you go in, you get better service because you're actually going through the internet. Well, that's the way this thing worked. It was a network extender, and when you connected to it, it boosted your signal so that you could get good service. The way that this network extender worked is when you got home, when you would come into the house, and this thing would only connect for about 50 feet. So when you came into the house, your phone automatically connected to this network extender. When you left home, it automatically disconnected from the network extender. You're going to hear proof from experts that that network extender was tested. And we know that Karen and Ashley Swift arrived home at 2:08 a.m. Now, the times are going to be very critical in this case. We're going to ask you to pay close attention to the time and pay close attention to the timelines. She arrived at home at 2:08 a.m., and we know this because her phone connected to the network extender. This is where the defendant's story starts to change. He told multiple stories about what happened when Karen Swift arrived at home. He told some people that he never saw Karen, but he talked to her from the top of the stairs. So he said he was standing at the top of the staircase. She was down at the bottom, but she was in an area where he couldn't see her, but he talked to her and made sure they were home. That's his first story. His next story is he was at the top of the staircase, that he actually did see Karen Swift. He talked to her, but he didn't know what she was wearing. His third story was that he was at the top of the staircase. Miss Swift came in. He saw her. He talked to her, and he knew what she was wearing, and he could describe in detail what she was wearing. And then his fourth story that you're going to hear from Jimmy Hancock is that he saw her when she came in. He saw what she was wearing. She went to bed and then later decided to leave, and he saw her when she was leaving and asked her where she was going, and she wouldn't tell him. 4 stories about what happened when she arrived home. He also told officers that as soon as Karen and Ashley got home, he went back to bed. And he said he slept all night, and he didn't get up till the next morning around 10 a.m. when the girls came in to say, hey, Dad, Mom's not here. Mom's missing. We don't know where she is. That was the story that he told. We're going to show you proof that that's not true either. We're going to put on proof that not only was he not asleep, he was up most of the night on his computer, on his phone, surfing internet sites, and he also was deleting pictures off of the computer and off of cameras of Miss Swift. Why would you delete photos of your wife that you care about, that you don't want to divorce? But we will prove that he was up deleting those photos. When Karen Swift arrived home that night, she dressed for bed. We're going to submit proof that she took something similar to a Tylenol PM, and she went to sleep. And she took Tylenol PM on a regular basis to help her sleep. She got into the bed along with Ashley. So now if you'll recall, Keely is upstairs with Mr. Swift. Now Ashley is downstairs with Miss Swift. The proof is going to show that sometime in the night, the defendant took Keely from his bed, brought her downstairs, and put her in the bed in Ashley's room. The proof is then going to show that he went into Karen Swift's room, got Ashley out of the bed, took her across the hall, and put her in the bed with Keely. He did that so that the children would not wake up, and that if one of them did wake up, they would have the other one in the bed with them, so they would go right back to sleep. We submit that the defendant then went into Miss Karen Swift's room. He gained control of her. He stripped her clothes, except for her panties, and he dragged her to the garage. Once inside the garage, the defendant stomped Karen on her head with such violence that it caved her skull in, and it caused shards of broken bone to enter her brain. The proof will show that it was such a violent blow that it severely fractured Karen's skull, and it did so from one side all the way across to the other. Proof's also going to show that it was such a violent blow that it separated the sutures. And you're going to hear from a doctor that when you're born as a baby, your skull is not quite connected yet. But as you grow, it starts to connect, and it creates sutures in your brain. And it was such a violent blow that it separated the sutures in the brain as well. After stomping Miss Swift's head on the concrete, the proof's going to show that there are fractures on the left side of the head, which show that it was against a solid object such as concrete, causing small fractures to this side and a large fracture to the other side. He then loaded Miss Karen Swift's body into a car. He went into his backyard and got bleach, and he used that to clean up what blood there was in the garage. He then drove up Harness Road, and he dumped her body near Bledsoe Cemetery and a large cross that overlooks the river and the Pagoda community. And this is a large cross that can be seen for a mile or more away, and it's a very popular and well-known in the community. And that's where her body was dumped. He then rushed back to the house. He got a screw and manually inserted the screw into Miss Swift's tire. This didn't cause the air to go out. So he had to intentionally deflate the tire, let all the air out of the tire, which is going to be the right front passenger tire. Once he did that, he put Karen Swift's purse and cell phone in the car. And we know this because her phone disconnects from the network extender at 4:38 a.m. She got home at 2:08 a.m., and it disconnects at 4:38 a.m. The defendant then drives Ms. Swift's car 1/4 of a mile, and it's at the intersection of Harness Road and Millsville Highway. He leaves the car there, and he does so to make it look like Ms. Swift drove down the road, got a flat, and someone abducted her. You're going to hear from Mary McQuarters. She's going to tell you that she lives right down the road from David and Karen Swift, or where they lived at that time. And at 4:40 a.m., she was awakened by the sound of a car with a flat tire being driven past her house. She's going to testify that the sound stopped when the car got to Millsfield Highway and Harness Road. As the defendant was walking back towards his house, if you'll remember, it was only 1/4 of a mile. So as he's walking back towards his house, he realized that he needed to get rid of Karen's phone. So the proof is going to show that her phone was receiving data all this time, but at 5:09, it suddenly stopped. Now, this phone was later found, and it was crushed. And we submit at 5:09, the defendant realized he had to do something with that phone, and he crushed it on the road the same way that he crushed her skull. At 5:09, the phone stops. At 5:15 a.m., Ms. Swift's car is seen by 2 different individuals driving down the road that knew her car and knew her. So only not that much. It was 5:09, only 6 minutes after the phone was crushed, her car is seen on the side of the road by 2 different individuals. A few days later, while they were searching, and Ms. Swift is missing, at that time she's just a missing person. So the Sheriff's Department has called everyone in that's available, help us search for this person, the community is searching, everyone is out searching for Ms. Swift. During that search, a highway patrol officer finds Karen Swift's cell phone, which was her iPhone, the one that was crushed, and they also find the Voyager phone, which is the phone that was loaned to her by the bonus. And they're both found together a few hundred feet from Mr. Swift's house. The defendant told investigators on several different occasions that he just found out that Ms. Swift had a second phone. He told them that he didn't know anything about this phone until after she was missing, and then he found out she had a second phone. We're going to put on proof that that was a lie. We're going to put on proof that the defendant knew she had a phone. He actually had the phone saved in his contacts, and he had called the phone numerous times. Another story that's not true. On October 30th of 2011, the morning that Ms. Swift was missing, Mr. Swift never called the police. He called his neighbor, Jenny Lamb, and this was sometime after lunch, around 1 o'clock or so. He called Jenny Lamb and asked her would she watch the girls for a little while, that Karen wasn't home, he was going to go look for her. And she told him at that time, well, her car's at the end of your road. It's just 1/4 of a mile up the road. It's right there parked on the side of the road. We saw it this morning. He then received a call from Kathy Bona just shortly after that. And she told Mr. Swift that she was concerned because she had not been able to get in contact with Karen, and that she always answered the phone, and she always texted her right back, and she couldn't get in touch with her, and she felt like something was wrong. At that time, Mr. Swift told them, well, I just found out that Karen's car is at the end of the road here at Millsfield Highway. The Bonas called the Sheriff's Department. They called before Mr. Swift did. They were first ones to call and say, hey, we've got a problem. We think Karen Swift is missing. Something's happened. They went straight to where her car was at that point. And when they get there, they're the first ones to arrive. Mr. Swift is not there at that time. Mr. Bona leaves to go try to look for Miss Swift. While Miss Bona was there and she's waiting on the sheriff's department, the defendant showed up. And the first officer to arrive was Deputy Brandon Alexander. He's going to testify that he searched the car. He didn't find anything suspicious at the time that he searched it. He then called his sergeant over the shift, who is Heath Walker. Sergeant Walker is going to testify also that when he came up, he looked at everything, but something just wasn't right. And he just felt like something wasn't right with this case. So he immediately called Chief Investigator Terry McCright, who just happened to be out of town with his pastor was in the hospital, and he was visiting with his pastor. Mr. McCright told him to impound the car, and he began an investigation immediately. Mr. Swift was initially interviewed by investigators Rick Gregory and Calvin Johnson. Now, Chief McCright listened to those interviews, and he just felt like something wasn't right with that interview. So he called and asked Mr. Swift if he would come back the next day for a second interview. And that was conducted by Chief McCright and TBI agent Nathan Bishop. There were several discrepancies between his story that he told the day before and the story he told the next day. After Karen had been missing for a few weeks, a search was conducted by the Tennessee Bureau of Investigation, and they did a search of the home of Mr. and Ms. Swift. While they were doing that search, they seized several electronic devices. It included cell phones, it included computers, numerous computers, cameras, and they took those devices back to the laboratory, and they downloaded all that information. And you're going to hear from those agents that did that, and they're going to explain to you exactly what was on those devices. They're going to tell you what the defendant was doing the morning that Ms. Swift came up missing and was murdered. They're going to tell you what the defendant was doing in the days that happened after she was missing. Now, the defendant's going to give you a lot of ideas. He's going to give you conspiracy theories. He's going to have all these rabbit holes that you can chase and go down. And they're doing that to try to take your focus off of the facts of this case. Was it a stranger who just happened upon Karen and abducted her and killed her within that few minutes? Was it a neighbor who didn't like dogs? Did he kill her because there was an issue over the dogs? Was it the prominent family in town? Were they the ones that killed Miss Swift? Or was it someone she was having a secret affair with? The problem with all of these theories is that none of them had a reason to kill Karen Swift. There's only one person who had the motive to kill, divorce, who had the means to kill, which was by stomping her, and who had the opportunity, because he was the last person to see Karen Swift and the only person that had the opportunity to do so. We're going to ask that you pay close attention to all of these witnesses that you're going to hear from. We specifically want you to pay attention to all of the lies that the defendant told throughout this investigation. At the close of the state's proof, we're going to have woven such a tight web around the defendant that it's impossible that anyone could have brutally murdered Karen Swift but the defendant. And we're going to ask you to find him guilty of first-degree premeditated murder. Thank you.
Mr. Taylor?
You are the members of the jury. You heard me talking earlier about, how serious it is to be on the jury. But let me start out by either congratulating you or telling you I'm sorry that you're on the jury, but you're chosen, and how important it is that we pay attention and listen through all the detail. The state just gave their take on this situation. Let me just talk to you about some issues and things that I want you to listen to as we go through the proof. And this is going to be a long trial because there's a lot of potential witnesses. Please listen to both sides. David and Karen Swift got married, as the prosecutor said, back in 1989. They've been together. David Swift had worked at manufacturing management for a period of time. Karen had worked a variety of jobs, part-time and stuff during that time. They had the 2 boys, and they did get divorced, and they reconciled. They were married in 89, and they got remarried on the same date in 2000. And then after they got remarried in 2000, and there were issues that they both had affairs, they tried to make the marriage work. They had 2 girls after that. And David Swift continued to work and be the major breadwinner for the family. Karen Swift and David were raising their family. As we move on till 2007, David Swift and Karen moved to Dyersburg because they started working at Tenaris in maintenance management. There were issues with the schools around there. Where he was working wasn't far. People commute. The schools were better in this area. It was a fresh start. And I guess it would be if you're having problems and you're looking to make something work. And so they moved to Dyersburg. David continued to work at Tenaris full-time. Karen was into fitness. She was very fit, very strong. It meant a lot to her. And she would get up early in the morning and sometimes leave, go to YMCA and go to classes. And it was just, she'd get up early and leave and go. As we move on until closer to 2011, Karen had friends, and they both lived in Dyersburg. They were both busy working. He was busy, David was, and with activities as kids, and she was. She worked part-time occasionally, did some landscape work eventually. And Karen had friends, and as happens in couples sometimes, one changes. And I submit to you that Karen had some friends she used to do activities with that lived around her, and they would do family-type activities. And it kind of started changing with Karen. And it became more of a wanting to drink and to go to clubs or different things like that, especially when she met the bonus. And it became a more frequent thing as we're moving closer to 2011. And it became an issue because something's changing. And in fact, some of her friends her lady friends that she met and made started sort of backing away from her because as she became more active with the bonus, there were issues about conduct and things that were going on, adult parties, things about hot tub parties and with the bonus and her and just some things that maybe some others considered not appropriate. David Swift started hearing about this, noticing that she's gone. They have the girls. They're small. And it becomes more of a frequent thing. She just would go somewhere and then be gone. And there are family responsibilities and things going on. And eventually, she's pretty active with the bonus. And there was some things that happened over there that David personally saw when he went over and heard about that caused him concern. And it was just some inappropriate conduct. And I think the proof's going to show that this went on. He's still working. He's still doing his part. He's trying to make it work. He's starting, like we talked about earlier, if you think that something's changing or if they're not being truthful to you or they're lying or they're sneaking out, he checked up on her. He was trying to find out if there was something going on. And trying to find out what was really going on, if we could trust her or not. As we move on to 2011, David did injure his knee in April of 2011, and the prosecutor referred to it. It was a serious knee injury in April of 2011, and it caused him to have crutches and operation. And we move on, and there's problems with the bonas, and it becomes, obvious and active at this time that Karen's going away a lot. And so sometime in Karen filed for divorce on October the 10th of 2011. And before that, the Bonas, they're the ones that provided her with another phone. And David and Karen had their plan, through a certain company. And yes, he got the records, but Mr. Bona kept up with Karen also about what her calls were and things. So he gave her a phone, and you have to decide, what's the situation here. She's a married woman, and he's given her a phone, and he's also providing her a way to go away. And she's over at their house. They're going to different things. They're going to clubs. They take her to a concert, in which she meets up with a guy, and they're sort of encouraging this behavior before she files for divorce and during this time. Karen did file for divorce. It was contested. She filed for divorce, and she did go to Gulf Shores with the Bonas. And, she didn't tell David till afterwards, until he found the note. And she took the two girls. The boys one's in college and the other one's getting ready to start college. And that's how he finds out. And so after a few days or a week, she comes back. She didn't ask for an order of protection. She didn't try to get her lawyer to put him out of their house. She goes back and lives in the house where David and the girls are, and his son is. And the other one, the oldest one, I think, is off to college. He's coming back occasionally. So her actions doesn't indicate she was fearful of David. And they're both in the house, and they're both carrying on with their lives. And they see each other. He's trying to figure out what's going to happen, what's going to go on. Is this another situation where we're going to have a problem and then try to work it out? And so that's going on. Around October the 25th of 2011, David re-injured his knee that had originally been seriously injured in April. We know that because the person that saw it, and this is before she goes missing October 30th. I guess the state is trying to tell you that that's some plan to commit murder. But it's an accident. It's an injury. He had the injury, but he re-injured himself. And it had an effect on his knee. And he had like a stabilizer on his knee, a mobilizer thing that he could strap on his left knee. He would wear that, and also had crutches. He couldn't, I submit that medical proof is going to show that it was hard for him to put weight on it, and that it made it stiff and hard to lift up and to walk a great distance, especially trying to carry something a great distance. Karen at this point will contend was 125 pounds, and people saw him with the crutches and the mobilizer. Now, there's a difference between a hay bale and a lady's body, the weight. And so, and there's proof that David was seen with crutches by different people, and at Walmart, and at the roller skating rink by some of these witnesses the 2 days before. And you're just going to have to listen to that and decide what you believe. Now, Karen goes missing Sunday morning. On Friday and Saturday, she was cleaning a house in Trimble, Tennessee. She was making some extra money for Habitat. She was cleaning the house. But and she would drive up there and go. And there was a hayride bonfire at the Swift's house where Karen and David are there at their house, and they're having like a little party, pre-Halloween for families and kids. And she's there and David's there, and they go get the hay, and they come back, and other people see him there. She's not afraid of him. She's around him. And then Saturday, I submit Karen went and cleaned the house in Trimble. And David went over, saw her, took his daughter with him, brought her lunch. He's still talking to her and trying to help her out and continue on. And a witness saw him. And it just doesn't add up that it's somebody trying to hurt somebody, but it's somebody trying to support somebody. And it may not be, they may be having problems, but can we make it work, or can we be adults about this? Saturday night, after doing the cleanup at Trimble, Karen goes to the party. And she did plan to stay all night. And David didn't call her back and say, come home. You know, her daughter, who was with somebody else that was supposed to spend the night, called her and said, come get me. I don't want to stay here anymore. And then Karen left the bonus, and they had been to the country club, and you know, they had been doing some activities there, drinking and, you know, at the party. And Karen was and went and picked her daughter up. And then she went home. She came home, and I submit to you that David was there. He said he heard or saw her, and that their children were there, the two girls. And then Sunday morning, October 30th, 2011, Karen goes missing. Now, before we get to that, Karen's plan was to get up Sunday morning and finish cleaning the bathrooms in the house at Trimble. So she would get up early and go do things, go to the gym, or that was her plan, to go to the house in Trimble and finish cleaning it up. And I mean, that's what he understood, or that's what her plan was, and she told other people. So it's not unusual that she'd get up and leave early in the morning. Now, the prosecutor said some things about her car. And her car was found a quarter mile from the house. And it did have a flat tire. And I guess you're going to have to ask yourself, what proof is there of all these things that the prosecutor's alleging or contending? That David, when she come home that Saturday night, early Sunday morning, and I submit there's no proof that David Swift left the house with his two girls there. And the prosecutor says that David Swift murders her and bashes her skull in a violent way in the garage of their home at 65 Willie Johnson Road. And there's nobody that heard any screaming or any disturbance. And you're going to hear that on that Sunday morning, after David Swift gets up, and there may be things with people using the computer at the house at different times. And the prosecutor said about Karen's phone registering on the extender before and after is consistent with Karen coming in and Karen leaving in her car. It was her car that she got in. Her car that was found down the road. Karen Swift was attractive woman that people said she could walk in Walmart and guys would go up to her and say things. She left, I contend the proof is she left the house. And there was a neighbor, Mr. I went blank, hog shooter, that lived across from him and down from him. And there was an issue with him poisoning their dog and their neighbor's dogs. And these cell phones were found in an area down from behind where he lived or where he had his property later on. And I don't know, the issue could be, you're going to hear from two different experts about the tires. There's another one that talk about what these tires do show or don't show and what tests were done or not done. This issue with a nail being intentionally drilled into the tire, whether the facts support that or not, you're going to have to decide after listening to both of them. David Swift got up. He does call and look for his wife. After a while, he don't hear from her. He talks to other people. He hears from somebody that he talks to, one of her friends, that she saw her car down the road. I submit to you that witness is going to say he acted like he was genuinely surprised and concerned. And he calls Mrs. Bonner. And he does go ask this lady to watch his children. And she's at the mall. He goes to the car, and then he goes to the mall, and then he comes back. And when he comes back, the Bonas are there, and they're out there. They're kind of really involved in Karen Swift's life and all of her activities. And he's concerned about the car's broken down. There's a flat tire. Where is she? And they call the police. Well, Mr. Bona does, to see if she's been arrested or in jail. And David does, but he's not sure what's going on. And it's not unlike Karen to get up and leave. And so before you bring the police in and say something, you want to at least make sure, because it can be embarrassing. But that's what's going on. From there, the law enforcement comes. Law enforcement comes. There's nothing in the car that indicates. The prosecutor said that her body was loaded in her car and driven down there and then driven back. Prosecutor said this grisly murder occurred in her garage, in their garage, while his daughters are in the house, and nobody's heard this. Law enforcement comes down after that this Sunday. Law enforcement comes into the house and looks around that day and in the days after, immediately after. Law enforcement very quickly looks through the house, takes pictures as they're going through, looking for anything unusual or anything that possibly might be questionable. TBI comes out, they're called in, they go through and do extensive analysis, I submit, of the house, of her car. They have search warrants for David's vehicle too. And they examine all these things. I mean, they go into the crawl space. They look at every bottle or container. They take samples from the garage. They take swabs from the garage to send off. And they send them off for analysis. The prosecutor says there's no scientific proof and don't concern yourself with it. But extensive things were done to all the things I'm telling you about. The house, all the rooms were looked at. The garage where he says this grisly thing happened, and her car, and also all the vehicles in the area around his house. They do walk down the road. They do continue searching and do all kinds of things. You're going to say there's proof that the cell phones were found behind where Mr. Hogshooter lived. There were issues with the neighbor they had a problem with, but if her car is on the side of the road down from where you live and it has a flat tire, issues about did she get out? What did she do? Who came up? I don't know, but there's no proof David Swift left the house during this time frame until he came out with his daughter and sees her vehicle after hearing about it, comes out looking for her after she's already gone, after he hears her car's out, with a flat tire, and he starts looking for her. There's no proof in the house or the garage or any of these physical things, and they did a lot of tests. They did do a lot of tests. They did blood tests. They did DNA tests. They did do ballistics tests. I don't know why, but they did. They took his weapons and did ballistic tests. I mean, they did a lot of things over a period of time. Her body was found December the 10th of 2011 down at Boathouse Cemetery. Some of the witnesses involved saw before that, driving down by the cemetery, people out there looking through the cemetery. It's an area out near the cemetery, real close. But I don't know. But her body is formally found December the 10th, 2011, down the road. It's about 2.9 miles away from the house. And yes, she had damage to her skull. Yes, it was an injury to her skull, and the medical examiner will tell you about it. He said it was a homicide, blunt force trauma, and that was the cause of her death. None of her clothes were found. Her panties were pulled down when they found her body. And I'm not trying to be crass or anything, but her panties were pulled down below, down towards her knees. It could look like a sexual assault. There was no semen found or DNA on the panties, but I don't know. But that's the state they found her body. And I'm not saying that to belittle or anything, but it looked like an assault. None of her clothes were found. None of her clothes, other than in her car, it looked like she had changed out of her clothes at the party. And her clothes were found in her car. There was no blood found in her car, her blood, or anything that indicated that her body had been loaded in her car, like the prosecutor said. These are things you need to look at and think about. He says, don't concern yourself if there's no scientific test. There's no proof through science or whatever, but they did a lot of things here. And what they don't show, he's trying to, I just submit, you got to ask yourself, is that realistic or reasonable? Now, after that, David Swift talked to him several times that day. He did call law enforcement. They did talk to him. They talked to him several times. He told him about his injury. It was just a fact of his state, how he was, at that point. But the prosecutor's making it seem like David Swift murdered her in their own home, in their garage, and there's no scientific evidence to back any of that up or proof of that. I submit to you there's no proof of where it occurred. Did somebody pick her up? I don't know, but he doesn't have to prove he's innocent. I'm not saying that, but there's no proof to back anything up that the prosecutor's saying about the location of the garage or anything of that, or her car. So those are things that I think you should concern yourself with. After that, 2011, he talked to him several times. They came back to the house several times. He agreed to let them come and search. Like I said, they even looked at the cleanup bottle out next to the pool. He had a bottle of bleach out there, and they checked it to see if there was anything on it. So they measured everything under the house. They looked at everything. In some ways, I've not seen as much documentation as I've seen in this case about those things, in some of the cases I've seen. After that, things go on. Nobody's charged for a long period of time. This is 2011. It becomes mentioned in a race for sheriff and the race for the district attorney's office that nothing's been done. Better do something about it. And over time, in 2022, the indictment was issued. After all those years, there's been no scientific breakthrough or anything other than what we just talked about. There's been nothing new that's come in or anything. After all this time, there was a charge. And it's important about proof, about asking, how do you prove what you're claiming? And so I ask you all, I could sit and talk about a lot of things here, but this is some of the issues that are going to be involved, some of the major issues. Sometimes when people are going through a divorce, they start talking about each other, both sides. They want you to understand how they've been wronged. And I submit to you, both parties were doing that before. And so, or sometimes they just want to talk to somebody about how they feel. So, please listen to all the questions of all the witnesses. And those are issues that I think you should look at as we're going through this trial. Thank you.
Thank you, Mr. Taylor. Ladies and gentlemen, honestly, we didn't think we'd get this far today. We thought it would take the better part of today to select you for service on the jury, and so we've gone as far as we can go today. We're going to let you all go in just a few minutes. We're going to start tomorrow morning. We need you here at 8:15 tomorrow morning, 8:15, and again, if you will report directly to the jury room like you did after lunch, just go straight to the jury room. At 8:15, we should be able to begin promptly at 8:30 tomorrow. If for some reason you have a problem, family issue, an illness, an emergency that you can't deal with, you need to call in or get someone to call into the clerk's office first thing in the morning so that we at least know there's a problem. Okay, I hope and I keep my fingers crossed that there's not for every reason, but certainly not right now. So we'll see you all in the morning. Before you get up and go, though, let me say this again. Don't discuss the case with anyone. Okay? If I was on the jury, I might be tempted to go home, get out my iPad or my computer, and try to see where Harness Road is in Dyer County. Don't do it. Don't get your phone out. Don't get your iPad out, computer out. Just don't do that. Do not speak with the attorneys, with the defendant, with any family members of the defendant or the victim, any person who claims to be a reporter or a media person. You're not permitted to give any interviews. They're not permitted to approach you at this time under any conditions, including if they say you'll just be an unnamed source. Don't do it. Do not do that. Do not form or express any opinion about this case. Again, there are many reports, a lot of information out here. Don't go home and look at it tonight. Please don't do that. You have to help me. I can't go home with you. And I'm not making you stay in a place where I can control the information flow. And so I need you to help me preserve the integrity of this trial and make sure that when you make a decision, that your decision is based on what you're going to hear in this courtroom only and exclusively in this courtroom there. So don't do anything that I've asked you not to do. Tomorrow morning I'll ask you again if you've done anything like that or if anyone has approached you, and you need to honestly assess what's going on in the intervening time. Any of you have any questions about any of that? in the period. I thank you very much for your attention this afternoon. Anything before we dismiss the jury for the day? No, Your Honor. No, Your Honor. Okay. All right, very good. We'll stand for you and let you all be dismissed.
All right.
All right, let's be seated. Junior, you be ready to go at 8:30 in the morning? Yeah, I'll be wanting you to call your first witness then. Mr. Taylor, or State, is there anything else we need to do before we adjourn for the day?
No, Your Honor. No.
Okay, we'll be here. I need you all here at 8:15 as well, or by 8:15 in the morning, and we'll start promptly at 8:30 tomorrow morning. All righty.
All right.
We're adjourned.
I don't ever slow up, no I don't take sh**. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take sh**. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take sh**. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're with my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take sh**. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take sh**. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some modestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is